Welcome to our Mary Greeley Primetime Alive presentation and estate planning primer. I'm Vicki Newell. I am the manager of the Primetime Alive program here at Mary Greeley. As a reminder, if you'd like more information about Primetime Alive, to sign up for a program and to join, you can go to mgmc.org/PTA. All right, our presenter today is Eric Adey. Eric is an Ames lawyer with 35 years of experience in a wide array of estate planning matters. He offers a unique perspective as a lawyer who has worked at the smallest law firm in Iowa, the office of Eric Adey in Fort Dodge, and now at the largest law firm in Iowa, Nyemaster Good. Please welcome Eric.
Good afternoon, everybody. And again, I'm not used to doing the online things. You'd think I would be, but I more typically just do them. This actually, I was telling Vicki, this is a lot bigger auditorium. I'd never been here, so I thought, it might be a little bit smaller. So it's a little daunting almost. So I feel like a rock star, but well, hopefully I'll perform like one. But I gave you that little bit of introduction that I had sent to Vicki, but just to fill that in, I went to Iowa State, graduated in '85. I was a botany horticulture major, and I went to the University of Iowa Law School, graduated in 1988. I got a lot of onlys. I was the only guy there, certainly, and one of the only guys probably around that has that undergrad degree and law degree. I still love that kind of area. I actually went to Washington, D.C. when I got out of the University of Iowa, worked for the USDA. I was with the Forest Service and what was ASCS in their general counsel's office there. So that was a real eye-opener for someone coming from, I grew up in Fort Dodge. So I spent a little over about a year and a half in Washington, D.C. working for the Office of General Counsel. A lot of great memories. It was when Ronald Reagan was actually my boss. Most people in this room, Ronald Reagan's still pretty forefront in your mind, but there's a lot of people, that weren't alive when Ronald Reagan was here. But George Bush actually took office when I was there, so I got to kind of enjoy that. Then I came back to Fort Dodge, and I worked at a firm that had 10 people, which is a pretty good-sized firm, particularly for a town that size, but even for Iowa, generally outside of maybe the biggest cities. And so I was exposed to a lot. I mean, I've done divorces, I've done drainage, I've done a lot of estate planning. I've done a lot of innumerable contracts, all sorts of real estate stuff. So I just really broad because when you start out, that's kind of how it is, and you kind of hopefully find your own niche. And then I made the move after being there for, I think, 15 years. I went on my own, stayed in Fort Dodge, competed against my own firm, which that's a whole nother topic, but it turned out pretty well. Again, that's a whole nother, when you're on your own working, it's just a totally different experience. When you literally are signing, the checks on the front and the back, and you're kind of in charge. I had three secretaries working for me, so it kind of opened your eyes as to what small business people go through. And then 2017, I actually relocated to Ames, and as she said, I went from my little law firm where I never had a meeting in 15 years to coming down to Nyemaster. I'm in the Ames office. There's only 3 attorneys. I was kind of slated to pick up for Dave Benson. I knew Dave a little bit from stuff I had done in Fort Dodge. And so, Dave's matriculated out, and his and my practice areas were very comparable. And so that was kind of the intent. And we're trying to get some younger folks in the office here hopefully the next couple of years. I just turned 60 last week, so that's kind of a milestone too. Gets me thinking maybe about my estate planning, So, and my dad died last year, and I took care of that, so that gave me a whole new kind of insight. You can tell people, but if you've lived it and gone through it, I think it's kind of helpful too. And certainly, I think it helped me because I'd done it enough times. But last name is Adey. That's how my grandfather, who was actually, his family was from like Cambridge area years and years ago. It's Norwegian. Nobody says Adey the first, a few people around here, because this is actually more Norwegian than say Fort Dodge was. But when someone, I go by almost anything you want to call me, Edie, 80, OD, whatever. So, but it is technically 80 for the true Norwegians out there like he was. Again, just a wide assortment of experiences, but I kind of settled in what I would call, when even my kids say, what do you do? It's kind of an office practice. That's how I would define it. Kind of a small Iowa County seat in a way, because Ames is really still kind of a small town, and when you get down to it. And in some ways it feels smaller than Fort Dodge because we had even more businesses, I think, based there. I come down here and some of the same businesses from Fort Dodge are actually doing work here, so which is kind of interesting. But again, I've kind of gone into what the office practice, which would be, the real estate, estate planning, probate, and just kind of contracts. I'm also the Iowa Institute for Co-ops lawyer, so I do a lot of co-op. The largest co-op in Iowa, new co-op, was in Fort Dodge. I started doing work for them 30-some years ago, and all they've done is grown. And so I continue to do that too. So again, I have a lot of different areas, and I think that's kind of helped me too. I do a lot of co-op presentations. I do a lot of board training, so I get in front of groups. And I think, as what Vicki said, I prefer interactive. I would force you guys all to move down the front if you were co-op board directors, but I can't do that. I guess I can't do that here. So, but this presentation, like most, can be kind of boring if I don't, get a little interaction. Again, the room is maybe a little big for that, but if you raise your hand, I'll catch you. And again, even though Vicki said you have to keep, if you want to talk about, co-op law or drainage in the middle of the thing, you can, just to kind of spice it up, feel free. But go ahead and interject. I used to sit and go to a lot of CLE, legal education classes, and these speakers would always say, yeah, there's no such thing as a dumb question. And I thought, gee, why do they always say that? And then once you do this, you realize they're just trying to egg people on to, because it is true. If you have a question, you're going to think maybe, oh, this is simple, or I should know it, or I'll ask him later. Just go ahead and chime in. It is probably true that some people have the same thing on their mind. So there really is no question that you should avoid. And I think it's a little easier if we do it as we go. But that's I guess we'll have time at the end as well. And I know the online folks have a way of doing that too. So usually when I get introduced as a speaker, a friend of mine who does the introduction says, hey, big treat, you got something you're never going to get, never going to hear again, free lawyer, free legal advice. So, and then I always come up after him and I say, but you get what you pay for. So that's kind of my disclaimer. But I've never done this. I've talked to some, I call them, retirement homes type settings where I've done a presentation. This one's new. I've actually kind of created this in the last couple of years as I've met with people. I tried to come up with a better way to present this, so it's a little less daunting. And I think it's pretty good actually, but we'll find out. So this is the first time I've given this particular one. I'm kind of testing it. So again, it would help, I think, if you ask questions, because that's going to help me improve this, because I almost invariably will change all my presentations. And my goals, I guess, when Vicki was asking me, I just came up with this name, but I think that's what it is, people, when you say estate planning, it really means planning to me. And I think for a lot of people, it means, look at my will. I get called all the time, hey, Dave did my will in 1988, and our kids are grown, and I need to, have you look at it. And so what I'm hoping to do here is introduce you to the concept of estate planning, and then so you'll walk out of here, and maybe even give you some secret information about attorney fees and costs, depending on how much time we have, if I get to that point. So any questions before we begin? You guys got anything you want to make sure I cover? All right, hearing none, I am going to turn to this overhead projector that I still use, and Vicki's going to tell me how to do it.
Tim will switch it over.
Oh, okay. All right. So again, this is, as you can see, I spent a lot of time typing this up because that's what I do. No, I don't like typing much, but it's easier for me to follow. I think it will be for you. So again, I call this estate planning options. I may have to come up with a new name for it, but what it is, again, it's supposed to introduce you to all the different roads, what I've called them when I meet with people, different roads that we can use in our estate planning journey if we want to, use that use that same syllabus here. So it's a little small, and we'll cover it, but conceptually what I've got here is this big A and B, okay? So A and B are simply two people. It can be husband and wife. I used to put HW, but it doesn't have to be. A could be a parent, B can be the children. The idea is what we're doing with estate planning is how do I get from A to B at A's death, okay? That's estate planning. So what are my roads in doing that? And so again, you can fill in A and B however you want. It can be a charity, it can be anything you want. And so I've got these different routes here numbered. And so I'm just going to go over number one, will, okay? So you probably all know what a will is, been around, Iowa 50, 60, our initial codes all pretty much followed English law like the rest of the country outside Louisiana and probably California. So we've had a probate code that's pretty tried and true, Chapter 633. It's pretty good sized. And when you hear the word probate, that's this avenue, if you will, from A to B, okay? So probate is simply the term that defines the process where assets and debts actually are distributed at the death of A. That's the name of the process, okay? It means you have to have a will, or you have to die without a will and no other way to do it, which would be intestacy. But so it's the way probate. I think if you go back and you dig through the Latin origin, it means to prove, because you have to there's a lot of formalities about proving this will is actually what the testator wanted. You have witnesses, and there's formality when you execute it. There's also a little formality when you present it to the court. You've got to have affidavits that this was, in fact, the last will and testament of this person. So what we're doing is we're proving that will, and the probate process is all court supervised and according to Iowa Code, Chapter 633. And 633 is, nothing that can ever possibly happen at someone's death is not covered. It just, we've been around since, again, mid 1800s. It was pretty good when it was written. It really hasn't had as many changes as you might think, because the process is pretty straightforward in a way. It's, when this is where you have the term executor. That's going to be your person who carries out this function and answers to the court. But basically, they collect the assets. They pay any debts, taxes, anything that's owed, and then finally they distribute. So it's collect, pay, distribute. Distribute according to what the will says. I leave everything to my kids. I leave 10% to the church and the rest to my kids. It can be, whatever a will can say. So that's tried, true, that's kind of maligned, and we'll talk about that too. People say, God, you got to avoid probate like the plague. It's attorney fees that are just, getting a lot of money. So again, there's some situations where you'll be darn glad there is a probate code, because if you've got any kind of messy situation at all, it's great. You always have a court backstop. You guys control the fees a little bit more than you probably think. Everything's negotiable. So it's kind of a thing that's I won't say it's fallen out of favor, because there's, probably 10 estates in Story County as we sit here going on, and multiply that across the state. It still works. Even in fairly recently, that might be the route you take. And what's really important about my overhead here is that each of these routes from A to B is separate and unique, and an asset has to travel along one. It can't, you can mix and match them, but, so you're not limited. If you have a will, all of these are available all the time. And so you have to plug the asset into the right route where you want to go. And there's sometimes, probate would cover everything, because it's designed to, it was the only thing around when we started. That was the only way to work this. So it can cover everything. Some of the other ones have limitations on what they can cover. But again, the idea of the reason we call it planning is because it's, you got to kind of understand this, because there's different ways to move assets, and there's different reasons, to use different routes. So anyway, that's old, reliable, will, probate, you file with the court. the papers, you open it, you file with the court the inventory of the assets, and eventually you file with the court the closing final report. And in the process, what you do is there's notices to everybody. I'm sure you've read the paper, and you probably have never read them. Next time you get one, you'll read it. But it's a notice to everybody that says, hear ye, John Doe has passed away, his estate is pending. If you've got any claims against him, bring them. If you owe him any money, it actually says that, you're supposed to contact them so you know. So it's a very regimented process that really works good. It's all based on notice, hearings if you need them, until you get to that final report. So I'll stop for them. Any questions on the famous probate that you hear about? Okay, we'll go to route number 2. I might be out of here by,
I can go.
yeah.
So in assigning your executor, that should be in your will, who is the executor, correct?
Your will has to nominate an executor,
It
yes.
has to nominate.
Yep.
Okay, so like if I pass away, and I can nominate my husband as executor?
Sure, yeah,
Okay.
yeah.
Thank you.
Yep.
Can you repeat what
She was asking about, the executor is the person in the probate process who's under court authority, files an oath. I hereby solemnly swear that I'll follow the Constitution, state of Iowa laws, and the terms of the will. And that executor is charged with doing the collect, pay, distribute. They carry out the functions. They're the ones who, at the moment of death or the moment they get appointed, they've got the power to act on behalf of the estate, which is basically when you die, certainly for tax purposes, you don't die. You just become an estate. And so that's a person basically. And the executor is the one who is in charge of running that whole process to the end. And at the very end, the court files an order that says, I hereby find that the executor has done everything they're supposed to do in accordance with law, and I discharge him. So that's the person in your will. You nominate your executor, and usually maybe a second executor too. So, yeah.
In the case where you say collect money from those that owe the estate,
Yeah.
how is that done? How does the executor know that so-and-so owes the estate?
Well, I mean, actually, that notice is it's a little, maybe it's far-fetched to think it happens much because I've never seen it. But I mean, when someone dies, you typically, I mean, remember it's collect, and that's an asset. If somebody owes me money, that's an asset. Okay. So my job in collecting or marshaling the asset, that's my number one job. So I got to figure that out. So, one word of advice that I think is pretty obvious is the more you can do to have your executor understand what your assets are. The people, my dad was a perfect example. He's 95. And I'd go out and see him, and he, for 10 years we talk about this, but he had a book where everything was in it. And so, yeah, it was a big thing for him. He's super organized, wanted to make sure, if I'm gone and mom's here, here's where everything is, and that's so helpful. And presumably, if somebody owes you a lot of money, there'll be a note or something, to evidence that, because that's just like any other asset. It's got value, and that's the job of the executor. So,
Are executors usually reimbursed or paid any kind of fee or?
yeah, they're entitled one more time, and you can really be mad because I'm not used to that. So the question is, are executors entitled to reimbursement? And the answer is yes. It's all, again, we got the Iowa Probate Code. And so the Iowa Probate Code says the maximum amount that an executor is entitled to is 2% of the gross value of the assets. The exact same numbers for attorneys. It's the same code provision. It's actually two provisions, but it's the same calculation. 2% of the gross value of the estate is the maximum fee. There is a provision where you can ask for extraordinary fees if you've done something extraordinary, but if you're an attorney, make sure you know the judge pretty well, because that's not looked upon greatly. But there is a way, but generally, and quite frankly, most executors that are, say, a spouse or even kids, one kid, it's income, okay? So you get taxed income. So if you're a child inheriting, you're better off, getting it as a distribution from the estate. And you get reimbursed, I guess I'm trying to remember if I got reimbursed. My dad died in Colorado. And, you go out there a lot more than you think, before and after. But, you can get that kind of stuff reimbursed too. But if you can't, if for some reason you couldn't have an agreement among the beneficiaries, the court just decides. And so, you just submit an application and tell them what you did and it's there. But yeah, so there's a maximum fee is all. And that's just under probate because, each one of these, again, there's different things. Now, remember, the one thing to remember is when we do probate, we do have to have an inventory of all assets. So that's not telling us, that doesn't matter how it gets over. They just want to know the value of everything going from A to B. I don't care how, but and the reason for the inventory, in the older days, we had an inheritance tax that actually was back between spouses. And we've winnowed that thing down now, where the inheritance tax goes away completely in 2025. But there still is one, if you leave something to a nephew or somebody who's not in your direct line of ascendancy or descendancy, there still is an Iowa inheritance tax. And so that's based on the value you put on the inventory. So that's why you do the inventory. And the inventory also is your income tax basis, which is a really big deal. So, if you inherit a farm, the classic Iowa case, and you turn around and sell it 10 years later, the question is, what's your basis? You're going to hear, what's my value? And that's going to be taken from the inventory. So, it does have a role. Again, it's supposed to be all assets. I mean, I don't get down to household furnishings too much, unless there's something special value, but that's the idea behind that. Anything else? Okay. I'll move on to number 2. So this is the revocable or living trust, however you hear it both ways. I think revocable maybe, I never understood living. I don't know, I guess. But people use it. I like revocable. So revocable trusts, they're not really quite, I wouldn't say they're new. They're newer to Iowa than they are a lot of places. I didn't see them when I started practicing, say, early 90s. They were just for rich people, it's like, hey, I gotta have a trust set up, to protect my stuff. And that tied in a little bit with the fact that we had at that time a much lower federal estate tax. So you got an Iowa inheritance tax, which is maximum 10%. That's a death tax that we don't really think about a lot because it doesn't come into play. There's also a federal death tax, estate tax, big because it's a high tax. It starts, in the 40% range. So that was always the one that we've been trying to avoid. And that was really part of estate planning until they recently, over the last 10 years, the federal estate tax exemption has now risen to, I hope there's nobody that knows because I'll look bad, it's $15 or $16 million per person. So a husband and wife can transfer $30 million to either during life or death. You can gift it as well without any federal estate tax. So the number of people obviously affected by federal estate tax it used to be 600,000 when I started. Now it's 30 million. So, now everybody had a house in Ames, you could hit it pretty quick and farmland quick, but now it's rare. There just aren't that many $30 million estates running around. I mean, they're, again, particularly maybe in Iowa, but that has fallen away as far as a planning thought. And it kind of worries me because I had a partner, office partner. He was 85 when he died, and that's been 15 years ago. But he was a old-time estate planning attorney who was just, wise, truly wise, and had lived through the entire, tax code basically. And he was so good at these clauses. If some of you have older wills, you'll see this very complicated language in there. And what that is, it was designed to make sure that the will operated so that they'd max out the tax benefits, the federal estate tax benefits. And that language it's kind of tricky. And again, it was automatic. You'd have something in there. And we've gotten so big in our exemption now that no one knows how to do it. I'm afraid no one's going to know how to do it if it keeps going much longer. But the federal estate tax exemption is up for vote 2025 as well, I think. So you won't hear about it until it gets close, like, because that's, I guess, how Washington works. But you'll be hearing about it because it's big. They passed this 10 years ago. They said it will go 600,000, 1 million, 2 million every year, going way up. And now it's got a sunset provision that says in 2025 it goes back to like 1 million. So you're going to hear a lot of senators. Luckily, they're all pretty wealthy, so they have a stake in the game. But it'll be a big deal because they're going to have to do something. And so we're all kind of wondering if you're close. If we knew what even was, what was possible, we could do more. So it's kind of a nervous time here every day until we figure out what that's going to be. Because if you don't have the right language, you can get burned by that tax. So that's kind of the world we're in right now. Everybody's waiting. You can guess all you want, but there's just no way to even estimate. No one would have predicted we'd be at like 15 million. It's indexed for inflation too, so it's taken some pretty good jumps. So, but that's part of the planning process. Any questions on the death taxes? There's 2 death taxes, state and federal. And the federal's the big one that doesn't come into play much. So number 2 road is revocable living trusts. And again, what those are, I say they're a will substitute, okay? So if you gave me your will and you said, Eric, I've been reading up on this. I read in Fortune magazine, I got to have a revocable trust to avoid probate. I would say, okay, I could take your will and it says, I hereby appoint my wife as my executor, and at my death, I leave everything to my wife, and if she predeceases me, to my children in equal shares per stirpes, and if any of them predecease me, it goes to their kids. That's what your will's, about 90% of them will probably say. Your trust is going to say, I hereby give to myself as trustee all of my assets, and they're to be managed by my trustee, which is me and then my spouse, and completely for my benefit. I can do whatever I want, all available for me. And then at my death, I just take and cut and paste your will and pop it right in there. It's the exact same thing. The trustee is directed to, at my death, my trustee shall, just like your will, pay the taxes, pay the debts, leave everything to my spouse if she survives me, if not to my kids, exact same language. So it's designed to be a will substitute. It's kind of a private probate, if you will. It was designed for, to some extent, to avoid probate, because probate has more costs, but it's kind of interesting how that's evolved a little bit too. And it's also kind of important if you had real estate in more than one state, because if you have, and that happens actually, you get called, hey, I'm in California, I inherited a farm, I set up a trust in California, I need to deed my farm to my trust. You hear it all the time, for Iowa farmland, because otherwise they'd have to have a probate in Iowa. And so when they have a trust, and it would work for an Iowa resident who's got a vacation home in Florida too, putting in a trust allows you to, again, have a little private probate where you don't have to go to all the different states. So that was kind of an obvious time when you'd use a revocable trust. But it's just a will. If you read it, it reads just like your will, other than the fact that you're designating a trustee. And the trustee, while you're alive, is usually yourself. And then typically, whoever you would have had as executor is your trustee, because they've got the same kind of duties. Except with a trust, it also, the assets are in there during your life, so it's, your trustee could probably would have the opportunity to manage your assets as trustee of your trust. So that's the magic of the revocable living trust. To me, I always have to complicate this. I've never had to figure out how to do this. You do have to have a little will on the side. That's kind of, if there's a mistake, it's called a pour over will. And that simply says, the idea with a living trust is all your assets are in the trust. Okay, so you don't have to go through probate because everything's in the trust, and your trust is, it tells your trustee how to do that. You don't have to have any court involvement. So it's not through probate. If for some reason, and it happens once a year at least, somebody sets up a trust and they forget to put something in there for whatever reason, that asset obviously can't be controlled by the trust because it's not in the trust. So then it has to go up to route number one, So you do have a will. It's called a pour-over will that says any assets I die with when I have a trust go to my trust. So all this designed, it's an insurance policy to make sure we kick everything back in because somebody missed doing it under the trust. But generally, your trust is a surrogate for your will. It says, does the exact same thing. Your trustees, and what's really, I don't know if it's funny or not, but so when these trusts come out and the attorneys are all thinking, well, okay, I mean, to get from A to B, I don't care how you do it, at least under 1 and 2, it's the same amount of work for me. I mean, I still got to do there's still an income tax return. Revocable trusts have no tax, advantages or disadvantages. They're neutral. I mean, they have no effect on your taxes. So, and if you're if you're an attorney and we're doing these trusts, we're thinking, well, gosh, how do we, if I'm a kid and I'm the trustee and I got 4 brothers and sisters I don't get along, which happens, you're thinking, man, if I was you, I'd like to make sure these kids are all on board. I want them to sign off on everything I did. So you end up, what was funny is you end up doing the same thing as you did under probate. If you were smart, you started to do the same kind of notices, and you do an inventory because you still got to do that income tax basis. Now you don't have any court to file it with, but you still got to have those numbers. So the process, as I guess you'd kind of expect, it's the exact same thing. And what's funny is, of course, Iowa adopted, there's an Iowa trust code, and if you read the papers carefully, and that the notices that you see that say hear ye, there's also one for trusts that says exactly the same thing as probate. It says Joe Blow died and had a trust, and if you owe the trust any money or have any claims against the trust, you've got so many months from the date of this publication. So kind of what you expected, I guess, if you thought about it. We're just, they're kind of merging the process because the probate thing really works well. So now when you settle a trust, you're still doing, you're still sending notices to all the other kids to make sure you're doing some kind of a final report to get it signed off on, and you still got to publish all your notices. That's actually by law now. So kind of an interesting, merger as the trust became more popular. So, and typically with a trust, at least if I'm doing it, you just like your will, you'd have one for the husband, one for the wife. And again, they read exactly like, if you can tell who's going to die first and you're really sure of it, I can probably get around that. But, otherwise that's the way to go, is to have each one. So that's usually the biggest decision of people that come in. I have a will, okay? And I could do this trust this afternoon if I wanted to. And I guess when I wrap up here, I think I'll explain to you why would I have a will. I'll tell you why I have a will. And some people I tell, I do a trust if I was you. Some people I say I do a will, and I'll tell you how I get to that answer. So anyway, those are comprehensive roads in the sense that all of your assets, if they're correctly titled, particularly for the trust, can follow those 2 routes, one of those 2 routes. Any questions?
With the pour-over will, if you've left out some asset, that has to go to probate, is that correct?
Yeah, Vicki, come on. You're gonna catch me again. Her question was, just to back up, a question about pour-over will. I've hopefully explained it decent enough, but if you decide I'm going to go with the revocable trust as my will, but as my way of moving my assets on my death, you still, out of an abundance of caution, execute a 1-page, maybe 2, will called a pour-over will that says, if I goofed up and I didn't get everything in the trust like I was supposed to, executor, put it into my trust. So you catch back up. And the question up here was, if I'm operating under a pour-over will, or I have an asset that didn't get put in the trust, does it have to go through probate? And it's not a yes or no, and that's not just because I'm an attorney, like my wife says. It kind of depends. There are, like cars. Cars don't go through. I can move a car by affidavit. I don't need a probate, So it's more typically real estate. You're kind of out of luck if it's real estate. That's the main one. there's a lot of accounts. There's a process under the Iowa code that if it's small enough amount in an account, you can also move it by affidavit. I should know this. They just raised the amount, I think, this year to, I want to say 100,000. It used to be 50. So if you died and you had a bank account of less than, give me time to double check this, but we'll say $100,000 for sake of discussion. That is one that, even though it's a probate asset, typically there's a provision under Iowa law to not have to go through the whole will thing. You can just do it by affidavit. So,
Another aspect of that is a living trust, as I understand it, is one of the main things I see good about it is private. And that what I heard recently was that a will, once it's been probated, is a public document. Anybody can go see how much went to who and everything. Where in a trust, it just continues without any publicity, really.
yeah, that's true. I should have mentioned that.
Nobody knows how much or who got what.
So, her comment was, we're the big selling points for trusts have always been avoiding probate, privacy, which was what was just mentioned, and also it's quicker. That one's debatable, but the privacy one is true. That probate files generally, again, there are some where court could seal them. I think Prince, I think, had that issue come up. He died, I think. Well, anyway, his probate in Minnesota, everybody was trying to get in there and see it, and the judge, he actually closed that one. But for the most part, probate files are a public record. And so, again, I find it hard to believe that people run down and look at that. I mean, you actually could go down to the courthouse when I first started, and it was a lot easier. It's harder now because you got to go log on and use their system. But yeah, that is true that trust is a private, arrangement. So there's no way for it to be public. And again, if you've got the right mix, I guess you could ask a judge to seal it. But generally, that is a selling point for trust, if that's a concern.
And Eric, I want to show you something. Tim switched this up, so there is a question, so you can now see them yourself. So if you want to read those as they come up, and then you can answer.
Okay, we've got a question here. 2:36 p.m. Is there a problem if the first spouse dies, but the second spouse doesn't follow the instructions for the trust? Well, yes, there's a problem. Whew. That was easy. Yeah, I mean, again, that kind of reiterates one of the advantages of probate. If you have can I say dysfunctional family? But if you have one where you got that concern, that's the beauty of probate is someone in a black robe will, correct everything going, and nothing can go too far astray. If you elect to go the trust route, it's private. Now, under the Iowa Trust Code, it says that any beneficiary or trustee can invoke the jurisdiction of the probate court. So we do have a fallback that if you want, I mean, the whole point was to avoid, the probate court, but if there's a problem in the administration of a trust, there is a way to, basically start a little mini lawsuit or at least a court file for a judge to start intervening and addressing issues. So, yep, there is a way. It's a problem, yes, and it can be corrected. Luckily, again, with the help of a judge. So, and that happens sometimes just to interpret a trust too. Yes.
So you mentioned that typically husband and wife have separate wills. Is it the same with the trusts? Do the spouses typically have separate trusts?
Yes. And so the question or the comment has to do with if this is a will substitute, is it similar in the sense that I have a will, my wife or husband has a will? Do I have a trust and they have a trust, or can we have one trust? In my office, you're each going to have one. And you can have a joint trust. You can have a joint will, by the way. And I've used them. They were really popular like in the 30s and 40s, and they're really underused, but that'll be our next discussion, joint mutual wills. But you can have a joint trust, but there's a lot of income tax complications with it because you have to trace basis through there, and it's just harder to do, because they get intermingled. And I mean, that was in vogue for about 3 years. Well, why have two if we can have one? I mean, it made sense, but then they found out, when you get an income tax problem, wish I had two. So pretty much, I mean, I think most people are going back to two, but you'll see one. I mean, they're out there. I've seen them a lot. I just don't like them because I don't want to run that risk.
I have a microphone. I'm going to come down so then he doesn't have to repeat everything.
Oh,
Thank you. Well, just to follow up then, what happens with joint ownership things like, your residence, for example? Do they go in both trusts? I'm just a novice at this, so these are really basic questions.
You've just anticipated. There's actually 7 of these roads, so we got how much time we got left. But the first 2 are the big ones because they can do all your assets. And the reason that you call this estate planning is, again, if the goal here today is for me to tell you how to get from A to B, those are the interstates. This is a pretty good analogy. I'm gonna have to start using this. But those are your big interstates because they can cover everything. But there's other ways to do it too, and they keep becoming more and more popular. Some of them, and some of them are very old and tried and true too. So that was a good lead-in, and you're not a plant either. But that's a really good lead-in for my number 3 here. If we're ready,
Let me come with the microphone.
Do you need to, for a trust, actually like a bank account have the word trust on it, or like for farmland have the word trust, the name or something on it to go into the account, to go into a trust? My parents had one and they had to do all of that. That was many years ago.
Yeah.
And is that still the same, that they had like the Jones Family Trust and they had to have that on their checks and everything else?
yeah. So the question is, do you have to have the word, the word trust? And I think digging a little deeper, when you set up a trust, you actually fund your trust with your assets. So all of your assets have to be transferred to the trust. So in the case of real estate, it's Mr. and Mrs. Jones hereby transfer to the Jones Family Trust. So yeah, the auditor is going to say, okay, Jones Family Trust on the plat book. So that's done. You go to the bank and you say, hey, I need to set up a trust account. Okay. Give me the ID number, give me the address. And again, they're going to put on the check. It's going to be, it's the owner of that account is a trust. So however they put on the checks, but yeah. So it's actually owned. Yes.
I have a question about fiduciaries. If one does those down the road, how do they do them and how does it apply to the trust?
Okay. The question is about fiduciary. So let's back up and what is a fiduciary? Fiduciary is somebody who's obligated to act in the best interest of someone else. Okay. So there's a lot of different fiduciaries in the world. There's executors, they'd be fiduciaries. Trustees would be fiduciaries. Guardians, conservators, powers of attorney agents are fiduciaries too. So the question is, how do you select them or what their duties are?
How they operate. You have to keep the original part of the trust, or does that eliminate that and put whatever changes you want?
I'm not quite following the question, but so if I'm a fiduciary, my duties either have to arise under law. Okay, so the probate code tells me I've got to do that, collect, pay, distribute. And it tells me if I sign on as executor, I file the oath of office, I've got to file the notices. I've got to do all these duties. Okay, I've got to pay the taxes. I've got to do that. If I'm a trustee, my duties, there are some legal duties now, like I said, publishing notice, but your duties arise by what your trust document tells you you're supposed to do. I mean, the trust document is what tells you your duties. You always have to act on behalf of the, you're an agent on behalf of a decedent, or, you could be a trustee and the grantor of the trust is still alive, and that's pretty common. So I don't know what you mean by original, but once you're a trustee or excuse me, a fiduciary, you always are until your duties expire either through closing the estate or closing the trust.
Okay, you've got your trust made, and down, I've heard of people deciding to make changes.
Okay?
And so then they have to do a fiduciary. So I'm trying to figure out,
No, I don't think, so the question is, if you change your trust, does that affect your fiduciary? So let's back up again. When you do your trust, it's going to name a trustee. It has to. It has to say, here's the trustees, typically yourself, and then you name successor trustees. The reason it's called revocable is it's revocable. So you can change anytime you want, do anything you want. And that would include changing your fiduciary or not. You could change anything in it. But if you change the fiduciary, of course, then that would change that. But it doesn't really change like duties or anything like that. Again, I'm not sure I'm hitting an answer that matches what you're saying, but you can amend your trust anytime, any way that you want to, but it doesn't really affect your fiduciary unless you change it. You can put you can limit your like some people. They have a big holding in Intel that they've had forever, and they just loved Intel, which was pretty good if you bought it at the right time. And normally, if you're a fiduciary and you got a stock account for somebody else, you better diversify that. It's pretty risky. But you can actually put language in your trust that says, "Hey, I've got Intel. I want Intel. I know it could go down, but I'm giving my trustee the ability to, to hold that." So there's things like that too. But
Back to the bank accounts. If you have a trust and don't want to put the bank accounts, all that wording on your check and everything, can you not just have it as directed to POD, payable on death, to the trust?
So the question is, if I don't know if the question is you don't want to move an account into a trust, or you just don't want the word trust on your checks. Can you use POD? I'm going to go over POD in a little bit.
Okay.
And maybe that'll answer your question. But again, I think you can have them put on your, a lot of people, if you've seen how these trusts, they're typically, the John and Joe Smith or the John R. Smith Revocable Trust dated, November 7th. That's typically how you label them. But I mean, if you go to a bank account and people are worried about what it says, I think you could just put Joe Smith Trust. I mean, it doesn't have to be exact. I'm sure they're going to want trust on there. That's kind of up to the bank, really, what they put on your. Funny story, if you think it's funny. My name on the new batch of checks I just got last couple months ago, it's just my name. It's a joint account. I didn't ask for it. My wife thinks I did. I don't know how they did it. And now I got to go through like 400 checks before I can get her name back on there. But so I don't. I mean, it's kind of a bank type deal. But you don't have to use the full name on the check if that's the issue. And I'll go over POD too.
Yeah. I was wondering, okay, let's say one spouse goes and you've done your will, together. Excuse me. Now, you need to do an update after one of you go, and is that more money, or how do you do that? Like, let's say a couple of kids go, and then one of your spouse goes, and you got to really revamp your will then?
Again, the question is, at the death of the first spouse, do you have to change your will? And again, as a lawyer, it kind of depends. But when you do your will, if you pull your wills out, it's going to say, I'm obviously speculating, but I mean, I know what a lot of them say. I leave everything to my spouse. If my spouse predeceases me, I leave everything to my kids in equal shares. And it'll say per stirpes, which means that if my children have children, it'll stay in that lineage. And you might have language about what happens if they're young. So you've kind of anticipated the fact that somebody might be dead. But, most people after a spouse dies, it's an opportunity to kind of look at things. So you may have other reasons to change it, but most wills have enough. I mean, they're designed to be flexible enough that they cover, the base, kind of the obvious death out of order type thing. But yeah, I mean, so it isn't like automatic. It just kind of depends, what your will says. You may want to just change what you do.
So it's how it's worded then?
Yes. Yep.
Okay.
Anything else? Any other questions? Okay, let's see where we are. You guys are already asking questions about these. So I'm just gonna bear it all here, I guess. Not literally. So I told you there were 7 roads. So again, remember, this is a way of getting from A to B. We covered the big ones, 1 and 2. Number 3 is joint tenancy. Joint tenancy, been around, again, English law, probably, I don't know, pre-Shakespeare, but it simply, I would bet a lot of money that anyone in this room that's married, their homestead is going to be in joint tenancy. And that's just kind of a tried and true method. And it simply says, if you look at your deed, it says to Joe and Mary Smith, husband and wife, as joint tenants with right of survivorship and not as tenants in common. And that's the magic language for joint tenancy. And all that means is if upon the death of one of the joint tenants, it automatically goes on Highway 3. Don't care what your will says. I mean, if once a thing moves on one of these roads, it can't go on the others. So joint tenancy, you could say in your will, I leave my house to my church. Tough luck church. If it's joint tenancy, it's going to the joint tenant. Okay, so that is that's no probate needed, nothing, just an affidavit, and that passes through. Okay, so that's another way to get from A to B. You can do joint tenancy on more than just real estate. I mean, you can do joint tenancy on. You can do it actually on stock too. I've seen it's kind of there's probably better ways to do it, but again, that's a tried and true method. The issue with joint tenancy you always have to keep in mind is if that federal estate tax comes back into play. We had a lot of people breaking their joint tenancies when the tax was a little bit lower because they didn't want it to automatically go because they couldn't do what they needed to do to lower the taxes. They wanted to stop it so they could, they wanted it to go through that fancy language under the will to take advantage of the deductions. So there were a lot of people that got out of joint tenancy. Right now, with the federal estate tax so high, it's not a tax issue. And again, if you want to, a lot of people have 2 trusts, and that there's a lot of ways to do it. You can have each of the trusts as the joint tenants. You could do that. You can have the surviving spouse just remember to deed that property into the trust upon the death of the first. That happens a lot too. So again, you can when it's estate planning, you can kind of use these different ways together, but at the actual event, it's going to follow one of those ways. And any questions on joint tenancy? So then what's another way to get from A to B? That would be a number 4. That's supposed to say designation, so my bad. I put designate. Beneficiary designation. Again, something that's been around forever. Life insurance, of course, been around, since Iowa was a state. And anyone who has a life insurance policy, who's the beneficiary? I mean, it's kind of ingrained. You have a primary beneficiary, a secondary beneficiary, and that's just those are just simply contract clauses that say, I've got this life insurance policy, for instance, and at my death, it goes to the person listed on Exhibit A, and if they're not around, to the listed behind them. So that's a beneficiary designation. It goes automatic and doesn't go through probate, not in your trust. Again, you could make the trust the beneficiary to route that if you wanted to do that. You can make your estate the beneficiary, but it's going to go wherever you put it. It doesn't matter what your will could say. I leave my life insurance to my daughter, but if the other daughter's on there, it's gone. Retirement accounts is the other one. Think of all your pensions, IRAs, whether it's employer sponsored or self-funded, any of the retirement accounts that are, qualified, they all have beneficiary designations. And that's the same thing there is so that's why, again, when you're thinking about estate planning, you got to figure out, okay, if I'm leaving this stuff in the trust, got to remember I got life insurance, I got, how do I do these retirement accounts, which can be fairly significant. I'll be honest with you. You come from Fort Dodge to Ames, there's this TIAA crap. No one heard about it in Fort Dodge. Here, because of so many people with Iowa State, you see it all the time. But those are things you gotta plan. You gotta make sure that everything jives. When you're moving along here. So that's the beneficiary designation. Number 5, I put POD/TOD, which was asked about before. That's pay on death. That really is a beneficiary designation. I ran out of room, I think. But it is a form of beneficiary designation that's called pay on death or transfer on death. One is a federal securities. If you own General Motors stock, you can have that titled in your name with a POD. Oh, wait a minute. I got to remember. Now I've just spaced off which is. One's for like bank accounts. I think that's POD. I got to go back and look. And the other is for like securities, would be POD. And so basically the same thing. It's just a beneficiary designation that each company, it's a contract. So if you go to a bank and say, I want a POD, or you go to General Motors and say, I want my stock TOD, they'll send you a form. This is the language that they'll insert basically on that. So that's going to automatically go to be at death without going through, any of the other avenues we've talked about. I added 6 not too long ago because so many people in Iowa are familiar with this. Again, it's certainly been used in Iowa for 150 plus years. That's a life estate. And a life estate was used you can do it in non-real estate, but it's certainly most applicable in the real estate world where a lot of farm estate plans were based this way. And they'd say, at my death, I leave my farmland to my wife in a life estate, and then at her death to my kids. And you can do that. You can do that under your will, or you can do it like in a deed. You can do it while you're alive. And what that does is same thing. So this spouse has the benefit and burdens of the property during life, and then at death, it automatically will go to whoever is listed as the remainder people under the deed or will. So that's another way, again, that doesn't matter, how you've otherwise, if you say, I want all my land to go here, but you've already set up a life estate remainder interest that's different, that's gonna rule. So that's why you got to kind of keep in mind. There's a lot of income tax issues with life estates too that can really, really be bad. So you have to kind of think about that, because the problem is when we talk about basis, it can go back to the time when the life estate was created. So I had a guy, true story, I had a guy who had a life estate for he had a remainder interest for 60 years. He was 2 years old when his dad died. And his dad had left to his mom in a life estate, and she lived his dad was young when he died, and she lived a long time. And this guy, so his basis was actually what it was 60 years ago in this land. It wasn't a good tax consequence, if he was going to sell it. But so again, you kind of got to be thinking about whether that works for you. But it's a real simple way to get from A to B. It's just, you do a deed, and it's worked for a long time in Iowa, particularly. Any questions on? Yeah. In the red.
Yeah, I have a question.
Hold on just a minute. So they can hear online.
Is it me? Yeah. Hello. Okay, my question is, I'm a little confused about this to begin with, but
I'm glad you didn't say because of this. So.
No way. All these categories and stuff. Now, how do they know to tax you on your death tax? Who files that? How do they know?
Being the government, or
how do what is it from?
Well, you
death
can't.
notice?
I guess it's the same way. How do they know if you file your income tax every year? You can run the risk, I guess, if you don't want to. But your executor is duty bound to pay taxes. So at least in the estate world, your trustee is going to be duty bound under the trust agreement. At my death, remember, collect, pay, distribute. That's still going to flow through. You got to pay. You got to pay anything I owe, and you've got to pay my taxes. So
Okay, let's say they pay all your bills,
yeah.
and then then we got to get taxed, right?
The income tax doesn't stop because you die. It just the day you die, then your estate becomes responsible. There's an estate tax return. Same, it's income tax, 1041 form, just, like a 1040. But you have to file that for any income that comes in after death or expenses.
Okay.
And in the probate world, again, one of the benefits of that, if you think this is a benefit, is you can't close the estate unless you tell the judge that you filed them and you've gotten the returns back approved at least by the state. So obviously the state, in the old days, that was, the state got confirmation of all that because you couldn't close the estate. It's a little harder now because there's a lot of stuff that's going not through probate, but you're still obligated legally. You still got a tax return due.
Okay. All right, thank you.
Anything else? So I threw number 7 on here because I was thinking about it today, just to kind of, when I was thinking about revocable trust, because people say, well, what's an irrevocable trust? And again, there's another way to get from A to B. It's not at death because I'm talking about gifts, but I just threw that in there. I haven't figured out where to put this on the chart, but obviously during life, I can get something from A to B by just gifting it to them. And I can simply gift it to my spouse or my kids, whether it's, money, car, land, whatever you want to do. You can transfer it, whatever the titling of that asset is, you can just do it. Also, revocable trust, that's where they come into play. Revocable trusts are used as a way to kind of make a gift without, making it completely. That's a revocable trust is set up, and it's irrevocable. That's the point. And it's a whole separate person for IRS purposes. But a lot of times they're used as a vehicle to receive assets and a gift because you can put some conditions on it without just saying, here's $100,000 or here's the farm. You can put it in an irrevocable trust that's got a little more control yet. What happens if they die and things like that? What happens if they get divorced? You can have those kind of things covered. So I just kind of threw that in because it's 3:04 and I didn't know how long we'd go, but the other thing I would have covered if I had more time, and so maybe I'll have to come back, but I was going to go, when people come in to see me, like on estate planning, there's like the big 3, it's like a safari, I guess. But you got, your will or trust, your main dispositional document. Then you also have powers of attorney, and that's what I probably won't have time to cover. But you've got a general power of attorney and a healthcare power of attorney that pretty much, you're going to kind of do those as a package deal because there's a lot of similar thought patterns going through it. Any questions? Let me see online. Wait a minute. Oh, here we go. I missed this one, but it's only 3:01 p.m., so not bad. Online question. Does beneficiary pay taxes on life insurance, retirement accounts, or POD inheritance? And of course, the kicker there is they didn't tell me what kind of taxes, so they're trying to trick me, but I won't be tricked. I think what they're trying to say is income taxes. No, so if I inherit a farm or a life insurance policy for $100,000, I don't pay income tax on that. It's not, it's mine, and once I start generating income from that, I do. If the question is, does a beneficiary pay inheritance tax or estate tax? Possibly, if we're over the limits and we're eligible. So if the question is which taxes, I'm going to guess they meant income taxes, and the answer is no. And potentially you would have a death tax. if you were not in the line of bloodline, or if you were above the 16 million, you could potentially be subject to federal, state, or Iowa state inheritance tax, but not income tax. Thumbs up. She liked it. No, I'm teasing you. So,
Okay.
any other final wrap-up questions? All right. Is there one? Oh, right. Yeah. Wait. Hold your applause. And then really let me have it. No.
Yes. Do the beneficiaries on the will supersede the beneficiaries in the retirement accounts and life insurance, or is it vice versa?
The question is, does a beneficiary as designated in a will trump a beneficiary otherwise named, for instance, in life insurance or another? I'm going to have some of you guys can answer that now.
No.
No. That's what I mean. They go on separate tracks, and so.
Okay. And one more question: what is the cost involved with getting living trust done?
Oh, yeah, I was going to run out of time. I mean, it just depends. I mean, everyone, of course, and that's a fair question. Hey, what's it cost to, and it's unfair to the attorney in a way, because I got a real simple estate, then you find out, it's not quite so simple. But so, I mean, it's usually just an hourly charge. I mean, it's whatever. And I mean, I would think most attorneys can, have an idea of what it'll be once they kind of, understand what they're up against. Simple is kind of in the eye of the beholder. But, so, you ask. I mean, I get asked all the time. That it? Okay.
Very good.
Thanks.
Danielle.
Yeah, I heard you were coming.
Yeah,
So you'll have to report to Vicki. We made it through.
I will. It was a great program. I was watching upstairs from my desk, and then
I didn't
ran
even
down
cover
to
my
catch
powers of attorney.
Yeah,
That could be the next one.
it could be the next one.
I spent all afternoon yesterday working on it.
Good. Well, thank you, Eric, for your time in preparing this presentation for Primetime Alive. We really appreciate it very much. So one more round of applause for Eric.
We got
All right.
an empty, working on another one. It's a tough crowd.
Our upcoming programs, weight management for older adults, will be here in the auditorium Wednesday, July 19th at 2 o'clock. And then we have a special program called Stop the Bleed, Save a Life, Tuesday, July 25th at 2 o'clock here in the auditorium. Now, please keep in mind for Stop the Bleed, that is the day that RAGBRAI is in town, so allow a little extra time to get here. And once again, thank you for joining us today.